Hey, what's up, Nebraska? Rod here with the NFOA. I know I haven't done an update for a few weeks, and that's mostly because there really hasn't been anything to report as far as gun laws go in the state of Nebraska. We had all the new bills introduced and kind of just sitting around waiting for those bills to be scheduled for a committee hearing. Now, they were all directed to the Judiciary Committee as expected, and well, with me being back, that must mean that there's something for me to say. And this is going to be a big week for gun owners in the state of Nebraska. You see, this week we have practically every gun bill that was introduced this session is going to be heard in the Judiciary Committee on Thursday. So what's on the agenda Thursday? Well, I'm just going to run through the list in the order that they're put on the agenda. That doesn't mean that they will be heard in that order. There's a good chance that they will be, but it's not unheard of for the chairman of the committee to reorder the sequence that bills are heard based upon how many people are there to testify on some of the bills. I have no idea what Steve Lathrop's going to do with the agenda. There's a good chance that he's just going to leave the agenda as it currently stands. So, first up is LB 54. Now, this was introduced by Senator Lowe. Its description is change provisions related to carrying a concealed weapon. Now, if we take a look at what's actually happening here, this is a reintroduction of a bill that he introduced for us last session. And it was in response to a Supreme Court ruling, Supreme Court of the state of Nebraska, that kind of changed how we interpret how we can legally carry a concealable weapon in our vehicles. Now, we just always assumed that as long as it's cased and unloaded, that you can carry it in your vehicle on the way to the range or home from the gun store, and you won't have any issues. But there was a case that was brought forth and appealed all the way to the Nebraska Supreme Court, and they had an interesting ruling that made it such that if you could access it, not necessarily while driving, that it would still be considered carrying a concealed weapon. Nebraska Statute 28-1202 says, except otherwise provided in the statute, any person who carries a weapon or weapons concealed on or about his or her person, such as a handgun, knife, brass, or iron knuckles, or any other deadly weapon, commits the offense of carrying a concealed weapon. LB 54 adds some language to that section that says the section does not apply to possessing, carrying, transporting, shipping, or receiving a firearm for any lawful purpose to or from any place where such firearm may be lawfully possessed or carried by a person if the firearm is unloaded and stored in a case, and such person is not otherwise prohibited by state or federal law from possessing, carrying, transporting, shipping, or receiving a firearm. This is an important protection that Nebraskans need. We shouldn't have to do this. This is in response to the Supreme Court ruling, and it's really just clarifying that if you have it cased and unloaded, you may transport it and not be in violation of Nebraska state law. We supported this bill last session. We're going to support it again this session. Next on the agenda is LB 58. This is a very dangerous bill. This bill was introduced by Senator Moorfeld, and he's calling it the Extreme Risk Protection Order Act. This is nothing but a red flag bill. This is a bill intended to allow law enforcement to come in if they think you're a risk or if somebody has accused you of being a risk, and confiscating all of your firearms before having your opportunity to go to court and have somebody prove their claim that you are a risk is in fact true. This is a clear violation of due process. Due process is not going after the fact and proving that the accusation against you was false. Due process is not going in front of a judge after the fact. Now, I'm sure you can come up with a myriad of ideas on your own as to why this is such a dangerous bill. You may have read in the news about law enforcement officers being killed when they've gone to confiscate somebody's weapons when they have not gone through due process. How many of you have a story of your own or of a family member or coworker of someone who's gone through a divorce and it's gotten dirty, where somebody has decided that they're going to make a false accusation against their spouse in order to gain the upper hand in trying to gain custody of the children. This type of bill is rife for abuse. The existing laws already provide everything necessary to get dangerous people the help they need and go through the proper channels in front of a judge. It's not too much of a stretch to think that somebody could abuse this in a way not only to gain an upper hand during a divorce proceeding, but perhaps somebody they're stalking, making a claim that, hey, this crazy person, they've been making threats against me, and I know they have a concealed handgun, so, you know, I really need a protection order against this person, and we need to make sure that they're disarmed. Just to turn around, and once this person is disarmed, now they can make their attack against that person without the risk of having them be able to defend themselves. I find that very disconcerting. Moving on, the next bill is LB 198, introduced by Senator Halloran. Now, this bill is supposed to change the provisions relating to the use of a deadly weapon to commit a felony and prohibit the use of a facsimile firearm to commit a felony. Now, this bill has been introduced and reintroduced a few times. It's intended to allow prosecutors to prosecute a violent criminal actor that used a facsimile weapon in the commission of a crime and charge them with the same additional criminal charge of using a deadly weapon as if it were when they were actually using a fake, or their term, facsimile weapon. Senator Halloran introduced LB 343 with the intention of creating a School Safety Rapid Response Option Act, which authorizes schools to allow employees to carry concealed handguns. Now, what this bill really does is remove a state-level restriction, a prohibition on firearms being in schools, with the specific exception that those schools that have decided they want to pursue the option of armed employees have the ability to have that discussion with the local school board, with the local community, with the local administration, and make that decision within the school district themselves, and not have a state make the wholesale prohibition saying no school may entertain that thought. You'll hear people say that this is a bill that will arm teachers. It doesn't arm anybody. It removes a state-level prohibition, like I said. To arm teachers implies that you are going to use taxpayer funds, acquire the firearms, and hand them out to the teachers. I have not seen that happen in any of the other states where they have enacted this type of bill. Again, this is only removing a state-level prohibition to allow school districts to have the conversation locally. LB 275 was introduced by Senator Hansen. This is a reintroduction again of something he's been chasing for a few years. It requires notification when persons prohibited by state or federal law attempts to obtain a handgun purchase permit or concealed handgun permit. I'm not sure what the value of this is other than creating an additional reporting requirement on law enforcement agencies. If a person applies for a permit and they are denied that permit, the agency that they applied is certainly capable of evaluating whether they need to do a further investigation on the individual that applied for the permit. Wouldn't you think that law enforcement agencies that issue these permits already maintain their own statistics internally as to how many permits they issue and how many they deny? As it currently stands, there's really not a good method for a person to identify whether they are a prohibited individual or not. Now, that might sound silly. Obviously, felons know that they're prohibited from owning a firearm. That's not what I'm talking about. I know there are a lot of folks out there that say, you know, many years ago I had a situation and I went to court but I can't tell you what the legal terms were used during that proceeding, and I don't know whether that situation that I was in resulted in me being prohibited from owning a firearm or not. The general recommendation has been, well, go to your county sheriff's office, apply for a firearm purchase certificate, see whether you get one or if you're denied. And if you're denied, you will then have the information from the sheriff as to what the specifics, according to that background check, that result in your prohibition. That is critical information for you to have in order for you to seek legal counsel to see if there's something that you can do to overturn that prohibition. Is this going to discourage you from applying for the permit just to find out whether you're allowed or disallowed to own a firearm? I fail to see how this is increasing safety or doing anything of any value. I do see additional requirements being placed on law enforcement agencies, which always ends up increasing the cost to them. Doesn't seem like a good use of taxpayer funds. The last bill on the agenda is LB 582. Now, it was introduced by Senator Brewer. Currently, Nebraska Statute 28-1212.03 says any person who possesses, receives, retains, or disposes of a firearm, stolen firearm, knowing it has been or believing it has been stolen, should be guilty of a Class 2A felony, unless the firearm is possessed with the intent of restoring it to the owner. So this goes on to add duplication of the language with minor tweak. Any person who possesses stolen firearm when they should have known or had reasonable cause to believe that the firearm had been stolen. So what we're doing is we're adding should have known in addition to the knows. So current law says if you know that it's been or believe it has been, this would add if you should have known or had a reasonable cause to believe. I imagine this is to address scenarios where prosecutors have been unable to prosecute because they couldn't prove that a person knew that they were in possession of a stolen firearm. But they could have shown that this person should have known that it was stolen. So what can you do? Well, number one, if there's any way you can make it down to Lincoln and attend the Judiciary Committee hearing on Thursday afternoon in person, that would be very helpful. The larger physical presence of people that are there to oppose that bill, the more powerful statement it'll make. Now, don't think that it won't get out of committee. I believe that it will get out of committee. But the other senators that are not part of the committee, they're going to see that physical presence. They're going to hear about how many people were lining the halls that couldn't get into the chamber if we have that many people there. That sends a powerful statement. We really need to have as many physical bodies down there that afternoon as possible. Now, where do you go? Well, the committee hearing starts at 1:30 in the afternoon. It could go kind of long if there's a lot of people to testify, and you are welcome to testify. If you enter the State Capitol building from the south entrance, the first hallway you encounter, turn left. Go down that hallway practically to the end, and on the right-hand side, you will see the Judiciary Committee hearing room. But what if you can't attend in person on Thursday? Well, you can write every member of the Judiciary Committee and let them know your thoughts. Let them know that you oppose LB 58. Let them know what bills you support. Let them know which bills you oppose. But here's the important thing. Each bill that you reference needs to be its own email. Now, what if you can't attend on Thursday, but you do want to testify? Well, you can do that too, through email. It's recommended that you put that in an attachment, either a Word document or save that as a PDF file and send that as an email to Senator Steve Lathrop. Steve Lathrop is the Judiciary Committee chairman, and his office will be accepting all of the written testimony up through 5 o'clock on Wednesday, the day before the hearing. I'm told it's 5 o'clock, but I would try to get it there before noon on Wednesday if at all possible. I have seen where they have made tweaks and all of a sudden some testimony that was submitted electronically could not be accepted because it missed the deadline. I know it's the day before. I've heard that it's 5 o'clock. I would suggest trying to get your written testimony in, if you want to provide it, prior to noon on Wednesday. If you were available to watch the proceedings, they will be televised. If you go to nebraskalegislature.gov, there is a link on that main webpage, and the link says Live Video Streaming, NET. Click on that and you can then select from the menu the Judiciary Committee. Once you click that link, you'll be presented with a list of different things that you can stream, and one of them will be the Judiciary Committee hearing. That's the one you want to listen to. Here are some initial thoughts on LB 58, Senator Moorfeld's red flag law bill. One of the things we noted is that much of the language of the bill is taken word for word from the Florida and Washington laws, and a Colorado bill that's currently pending. So this obviously was not drafted by Senator Moorfeld. He lifted language that has been utilized in other states. This bill would allow law enforcement to file a petition for an order to take guns away. But the bill would also allow lots of other people to file. Any family member, no matter how distantly related, current and former spouses, any person they have ever dated, and anyone who has ever been a roommate. The purpose of seeking an order under this proposed law is to have police take guns away by force if necessary. Here's something interesting. If a person violates the order by possessing a gun, it's a Class 2 misdemeanor. If a person files a petition they know is false or for the purpose of harassment, it's only a Class 3 misdemeanor, no matter how many times they do it. Understand that we do have an existing legal process to take away guns from convicted felons, accused felons while awaiting trial, and domestic violence offenders. People that are subject to a domestic violence protection order or harassment protection order. People who are seriously mentally ill, dishonorably discharged former service members, people who have renounced their citizenship, and illegal aliens. The state has a responsibility to protect the rights of its citizens, not to provide protection to the citizens, but protect their rights. This bill does not respect the Constitution of the state of Nebraska, does not respect the Constitution of the United States of America, and does not protect its citizens' rights. The existing criminal court proceedings are designed to protect the rights of its citizens. This bill sets a much lower bar. Not just dangerous mental illness, but any recurring mental health issue could be used to take away guns. What is considered a mental health issue? Somebody who's experiencing anxiety, somebody who has trouble sleeping because of PTSD. There's all kinds of things that can be used to abuse this. Do we really want to discourage people from seeking treatment? What about the veterans with PTSD or mild depression who are receiving support from the VA? This bill would say that is evidence that could be used to take away their rights. You need to let your senator and every senator on the Judiciary Committee understand that you take your gun rights seriously, that you take the Constitution seriously, that you take the state's responsibility to protect its citizens' rights seriously. I'm sure that the supporters of this bill will use plenty of emotional arguments as to why they need broader ability to take away a dangerous individual's guns. And I'm sure they will use some mass shootings as examples. If we look at some of those mass shootings as examples, we're going to find that many times, up to years prior to this event, people knew this person was a danger and they didn't do anything. That there were many instances where law enforcement in that jurisdiction knew this was a dangerous person and did nothing to follow through the existing process to try to address it. We have too many examples of government failing to do their job as they were supposed to do. We certainly don't need to give government or anyone else more power to just stomp all over somebody's rights and not go through an existing process that's designed to protect the rights of the individual. This bill is so rife for abuse. I'm sure you can come up with your own ideas as to how it can be misused. I encourage you to pick one or two, elaborate on that in an email, and send that to all of the Judiciary Committee members and let them know that you are greatly opposed to this bill. So what can we expect next? Well, the hearings obviously are on Thursday, the 28th. After that, at some point, probably within a week, the committee will go into an executive session and discuss the bills that were heard. And some of them will be voted on to advance, some of them will not. People can bring up, hey, I want to discuss this bill. And the committee will discuss it briefly and then vote on whether to advance it or not. And I can kind of get a feel for which bills are going to advance and which ones won't. I'm fairly confident that the red flag bill will actually advance out of committee. So then what? Well, it goes to the Speaker of the Legislature, gets on a pile of bills that have been passed out of committee, and it's up to him to determine when to schedule it for the entire legislature to debate. This bill, I don't know. I mean, it could come up in a couple of weeks, might be a couple of months. It could even carry over into the next session. So the more people we have opposing this now, the more that helps once it makes it to the floor. We will share more information with you if and when it makes it to that point as to which senator is going to lead the opposition and what we can do to assist that senator in opposing this. Now is not the time to be silent. You may only care about one of the bills that I mentioned is going to be heard on Thursday. If that's the case, please speak out on that bill. You may have an opinion on all of those bills. If that's the case, please write your senator and the Judiciary Committee members about every bill that you care about. Let them know your position. Let them know why that's your position. It can be short. Please make it respectful. But let them know firmly what your beliefs are. We'll come to you later with some more updates. This is all I really have to cover for this week. I don't want the videos to get any longer than necessary. So that's all I've got for this week. Stay tuned. We'll let you know more as we find out more. Probably give you a recap on what we saw during the hearings on Thursday in another week or so. And as we see things come out of committee, we'll let you know about that. If we have anything else important to share with you, we'll come back and let you know. Again, if you have questions for us you'd like to see me address in a future Q&A video or a possible live town hall coming up, send us an email, post in the comments below, join the NFOA forum, post questions out there, hit us up through Facebook Messenger. There's multiple ways of contacting us. Let us know what you want us to cover for future content. Until then, stay safe, Nebraska.